If you've spent the past few weeks wondering whether the Titanic was actually carrying gold bars in the first place, go ahead and subscribe, leave us a 5-star review. Welcome back to the Environmental Law Monitor podcast. This is Bracewell LLP's podcast on environmental and natural resources law and policy issues. I'm Daniel Pope, and I'm here with Taylor Stuart. We're your hosts for today. Hi, Taylor.
Hello, Daniel. It's great to be back.
It is great to be back. We've been gone for a minute.
We have been gone for a minute. I got married. I went on my honeymoon. It was an amazing time. Then I returned to DC and we had an inauguration. We had a change of administration. I think I got back on the 28th of January. And of course, the inauguration was on the 21st. So by the time I returned, so much had occurred and we have so much to talk about today.
That's right. And we are going to be touching on a lot of things really quickly today. There's a lot to talk about already. And of course, we knew that the opening days of any new administration can be topsy-turvy, chaotic, and we're all trying to figure out what's going to happen next. But one of the things that I keep comparing the past few weeks to is what we saw from the last administration when they jumped into the Oval Office. And I think on day one, we had a list of actions that the Biden administration wanted to review that President Trump had overseen in his time in office when he was the 45th president. And it was a very tidy, a very neat list of 100 or so regulatory actions that the Biden administration wanted to review. And I thought that, among other things, was very thoughtful of them because we had a kind of roadmap for where we were going to be going. And over the following months, you could say, oh yeah, they told us that they were going to be doing this. We don't have a similar list from the Trump administration, a little roadmap to what's going to be happening. But a lot of things are starting to happen, even if EPA hasn't been in the focus yet or splashing headlines across the New York Times and the Washington Post and the Wall Street Journal.
That's right. I think we're seeing a lot from the administration, of course, in the form of executive orders. And many of the orders sort of say, go forth agencies, come up with your own list, tell us which items we should be reviewing and looking over from the Biden administration. In that way, I think the kind of political playbook for the change administration is kind of foreseen, and we kind of saw that part coming. But of course, the Trump administration does things a little bit differently, right? They really try to kind of turn course from some of the traditions or normal ways of doing business. I think their voters are sort of looking for that type of dynamic. And we've definitely seen that from the administration so far. I mean, we've seen quite a few, I would say, unprecedented actions on their part. Which ones, I guess, have caught your eye that will most impact our work in the environmental legal field? I mean, there's so many of them to go over, but
there are a lot. And I guess they've sort of caught my eye, or rather, I'm sort of watching for what's going to happen next. One of the big ones that happened last week was the Council on Environmental Quality's action to remove NEPA regulations from the pages of that wonderful volume, the Code of Federal Regulations. And we've been talking about this on this podcast really at length. I need to go back and figure out how many NEPA episodes that we've done.
Yeah, I mean, it's been back and forth for so many years now.
That's right. We talked about Trump-era regulations, the Biden Phase 1 and Phase 2 regulations. Then I think most recently we gathered around the microphones to talk about the decision of the DC Circuit saying that, oh, well, we're not even sure, and we're actually somewhat sure that CEQ doesn't have the authority to issue NEPA regulations. And that and one other case has led this administration to issue an interim final rule removing those regulations from the CFR. So I think that just raises tons of questions. We're going to have a NEPA-specific episode to explore those in depth. One thing that's kind of interesting is, okay, well, how does this affect a 7-county infrastructure coalition, which has already been fully briefed, argued at length before the Supreme Court, but we don't have an opinion there. The Solicitor General's office submitted a notice, I think, last month, shortly after the Trump administration came in saying, hey, these rules have been flagged for review. We're going to be taking a look at them. And I imagine that in the next few days, we're going to see a similar letter saying, oh, and they've been removed because compliance with those regulations is part of what's going on in that case.
And you mentioned the interim final rule. Of course, that came along with this guidance from CEQ that's sort of telling agencies what they should do now that the agency is moving to rescind their NEPA regulations. The guidance was really interesting. I found it to be pretty high level. I don't know that it really actually gives that much guidance to the agencies. I think they might look at that document and feel confused. It basically just says comply with the statute, comply with the executive order on unleashing American energy, and take a look at what we say in this guidance and take that into account as you're preparing your NEPA analyses. I think a lot of clients have already started reaching out to us asking, what does this mean? Agencies are going to start, and they've been directed to revise their NEPA procedures to try to comply with these directions. But the directions are sort of unclear, it's ambiguous. And then, of course, you have decades of case law that are interpreting the CEQ regulations. And courts, I think, will have to kind of unwind which items they've previously ruled on came from the regulations, which were actually creatures of the statute. I think it's going to be a while until we sort of have a level playing field on the NEPA front. And for most urgently, I think the agencies owe all federal agencies that have NEPA procedures, CEQ, a schedule for revising them within 30 days, and then they have to finish the revisions within a year. So at least for the next year, I think people will be asking the question, how do we prepare our project permit applications? If we're an agency, how do we prepare NEPA analyses? What do we comply with? I think it's going to be an interesting 12 months on the NEPA front.
And like, what do we do if we're midway through? Putting together all the documentation, all the analyses for an EIS or even an environmental assessment, which isn't mentioned, I don't think. Well, I'm going to put a pin in that. I need to go back and see if the IRA made a reference. I think that adds environmental assessment back in.
That's another thing that the guidance sort of took into account is we have these FRA amendments to NEPA that are pretty recent. So the guidance sort of says, take into account the recent NEPA regulations. They add sort of these like cornerstone items that came from the CEQ regulations, like environmental assessment versus environmental impact statement, but they don't add things like cumulative impacts or environmental justice. So the administration was quick to say, you don't need to incorporate things like that in your NEPA analyses. And they did. I was glad, I think, and I think a lot of people will be glad to see this one clarification that they sort of encourage agencies that were midway through their NEPA processes or agencies that are in the process of defending their NEPA analyses to rely on and defend use of the previous CEQ regulations. I think that will provide a good amount of clarity for some of these agencies that if they're 50% done and they're using the 2024 regulations, are they really supposed to sit this aside and delay whatever they're working on? So I thought that was one good clarification I think that came out of the guidance is, we're, as the administration, we're fine with you using these previous versions of the regulations if it means that you're propelling forward analyses that you were already working on, because at the end of the day, we see the administration's number one priority being unleashing American energy and promoting those projects forward.
That just raises, I have like 5 more questions coming out of that now, because it's like, okay, well, if I don't like a project, then maybe I will say, oh yeah, these regulations that you complied with are ultra vires. I'm talking about something in the statute. And anytime we talk about NEPA's statutory text, I just think of our colleague, Kevin Ewing, and how he always talks about how lofty and ambitious the statutory language is. And sometimes that's not the most specific. But before we turn this into an accidental NEPA episode,
that's right.
Which
we could easily do it. Yes.
I mean, we both practice in that. We could do that. What's something that you're paying attention to? What are you looking out for?
I think the other things I'm paying attention to in the short term, I'm really watching changes in federal workforce. We've, of course, seen the administration take actions that are intended to just reduce the overall size of the federal workforce. That obviously has an impact on our work, on people that are environmental legal practitioners. If you're seeking permits, if you're really communicating with federal agencies at all, if you need things from them, if you're seeking documents under FOIA from them, if you are litigating against them, I think that is going to really impact the way that your work looks on a day-to-day basis. If certain teams that you're working across from or working with are substantially reduced. And I think the other item I'm really looking at is citizen suits. I think we should expect to see a real uptick, as if we haven't already, but I think we will really expect to see an uptick of citizen suits by NGOs that are challenging Trump administration actions. think they're watching very closely for anything that the administration does on the environmental or energy front. They are poised and well-funded to challenge those. And the other question is, the Trump administration now has all of these Biden administration approvals or actions that it needs to decide whether to defend those or whether to sort of rescind the underlying action that's been challenged and just tell a court that it's going to take a step back. So I think that's going to be really interesting in the next 30 to 60 days. What actions do NGOs take to challenge some of these federal actions? And then what do federal agencies do if they're already in litigation and maybe they've had prosecutors leave, maybe they've had team members leave? Are they going to proceed with some of these cases? Are they going to defend prior Biden administration actions? Are they going to throw them out? I think it could go so many ways.
Right. What happens if a rule has been proposed and the comment period has closed? What's the administration going to do with that? What's it going to do with a final rule that is just now being challenged and maybe the briefing has just started? And then, of course, what do they do with that in the courts? So yeah, there's one that I'm also paying attention to, and it's very much connected with that whole transition of government, and that is the Congressional Review Act. House Republicans have been talking about a handful of actions from the previous administration that they want to review under the CRA. And one of the ones that's probably most relevant for our clients is the waste emissions charge, aka the methane fee. What's interesting about the methane fee is that it's not just an EPA agency creation, right? This is part of the IRA, the Inflation Reduction Act, and as part of the sort of bipartisan settlement for all of the things included in the IRA. So I'm looking to see whether that is going to move forward because we just got the final rule in November of 2024. And I'm also curious, as I am every time we talk about the CRA, the limitations on an agency's ability to issue a substantially similar rule to one that was struck down with the CRA.
Yeah, I wonder if we're going to see that.
Potentially non-justiciable, not sure. We're going to find out maybe.
Yeah, this is the peak of me and Daniel's nerdness because we really want to see this litigated.
Right.
Maybe not by us because there are many hard arguments to make. It's like an issue of first impression, I think. But
please hire us if you want to.
Yeah, we could try.
But yeah, they're just going to be, and Taylor, I know you spent tons of time with like the good neighbor rule, the greenhouse gas emissions rule making, and what are we going to see there? It's going to be interesting to watch.
It's going to be really interesting to watch how this administration tries to roll back some of these things. I mean, I think just as they did in 2017 and just as the Biden administration did in 2021, they're going to experience, I think, some problems with the courts as they try to roll some of these items back. We've already seen with the Good Neighbor Rule, which our listeners might recall, we did an episode on that last year. That is the rulemaking by EPA to further regulate ozone NACs and particularly impacts on downstream air quality across the United States. So the idea that you have to be a good neighbor to your fellow states when it comes to attainment and complying with EPA's air regulations. We've been watching that litigation closely, and we actually saw the new Trump administration EPA seek an abeyance in that case in the DC Circuit, of course, wanting to pause it while they sort of get their arms around the Good Neighbor Rule and decide what they want to do with the rule. Probably everyone expects, of course, that they'll try to roll it back and to basically rescind the rule. But they sought an abeyance from the DC Circuit. The case is essentially almost all the way briefed. And we saw on Friday that the DC Circuit said, actually, no, we're going to deny the abeyance. They set today, as we're recording this, they set oral argument for the end of April. So they're telling the Trump administration, you need to come in and defend this rule. We've briefed all these issues. We've lived this case for the past 2 years where the court has invested resources in it. We want to see what you have to say. So it'll be really interesting to see how the administration handles that. Presumably, would they come to oral argument and explain to the court that they are no longer seeking to carry this rule forward? That one will be really one to watch because I think it's one where the administration's trying to take a step back and the court is saying, actually, no, it's too late for that.
Yeah, that just makes me think about something that we've talked about for the past 4 or 5 years, which is the difficulties of some of these like longer lead time, complex rulemakings with a one-term president, right? And we're going to have a one-term president. It's Trump 47, right? So what are the initiatives going to be? So much of what we're seeing right now is looking backwards, right? What did we see under the past 4 years and what don't we like, right? Okay, there's an environmental justice emphasis. We're going to scratch that. We're seeing a climate change emphasis. Okay, well, this administration is going to take a different position there. But what rules will this administration develop to unleash American energy, if it develops those rules at all? And will it be able to get those rules out the door and defend them so that we don't have yet another round? Like we're gathering together in early 2029 and we're like, okay, well, we've got a new administration. What's continuing? What's not continuing? And we just do this all over again. I'm also interested, and these are also a set of rule-like actions, but I mean, it's Endangered Species Act listings and critical habitat designations. There are a number of them that were Fish and Wildlife Service or the National Marine Fisheries Service proposed. The comment period has been closed for months now. If you go back on and take a look at the unified agenda, many of these final actions to list species as endangered or threatened or to designate critical habitat were due November, December of 2024, and they're likely not coming along. And to circle back to your comment about citizen suits, right? I mean, under the Endangered Species Act, there's a time frame in which the services have an opportunity to that they've got to comply with. Really, it's a deadline to take action on a proposed listing or a proposed critical habitat designation. And that has been an area in the past where we've seen some NGO activity, right? They push the services in the courts to stick to the deadline, hoping to get an order from the court saying, well, you've got 6 more months to do this, but gosh darn it, you better meet that deadline. And then they litigate the subsequent decision, if it's a decision not to list or a decision not to designate. We talked about this at our last seminar a little bit. I've been following the Rice's whale, which is this critically endangered whale, and the Gulf is just the Gulf for me right now. And that there was going to be a pretty large part of the Gulf that was going to be designated as critical habitat, and we'll see what happens. I set up Google alerts for Rice's whale, and I'm getting emails like multiple times a day. I'm really not good at inbox management.
So I was forever with the northern long-eared bat, just constantly looking up. I think that's a good example, though, of one where, yeah, the Rice's whale designation was arguably, and should it be adopted, will kind of put in place obstacles to offshore oil and gas development, and offshore oil and gas developers need to get out from the ports in Texas and Louisiana out to their offshore rigs. If they have to drive their vessels at 10 knots, that is just not really going to work for them. So that's something that the Trump administration could easily, I think, seize upon and say, oh, this is an obstacle to oil and gas development, which is something that they're clearly prioritizing. We're not going to carry this forward. The problem with many of the issues I think that you and I deal with in our practice, Daniel, is they really are highly scientific. And the underlying support for many of these regulatory actions is based on science. And so to undo them or to try to run them back in the face of a court, you need to have countervailing science that says something different. Maybe they would need to come up with a study. Maybe they need to offer some other evidence that has changed their view. Otherwise, a court could easily decide that is arbitrary and capricious decision making. And, it's interesting having to, if you're dealing with NIMS, the National Marine Fisheries Service, and the Biden administration maybe 2 years ago has asked them for a particular scientific study or a particular opinion on one topic or another. And then you turn around 2 years later and you have to ask the same team of scientific experts if they can reassess that decision. It gets into the, I think, complicated nature of federal rulemaking around policy preferences, because there are areas that are based on a lot of science, and there are courts that are going to sort of hold you to that standard and tell you that you have to prove that you didn't arbitrarily and capriciously decide this based on politics. And I think both political parties really in the last 2 decades have really struggled to do that. there's such an extreme shift each time each administration changes. And then there's so much arguably to be done and undone. And it's going to be very interesting this time around to see how the Trump administration goes about that, because I think the path that they take may be different than the one that they took in 2017, because they did kind of get kicked back by a couple courts who told them that this isn't making sense to us.
Two thoughts on rice as well. The other thing that's interesting is that we've got the critical habitat and then also this guidance from BOEM that they just rescinded, which is kind of an indication maybe of where federal agencies are going with respect to the rice as well. But there's also litigation over the biological opinion that basically undergirds offshore leasing in the Gulf. And a judge overseeing that case has already concluded that the existing biological opinion is arbitrary and capricious because it leaves out X, Y, and Z. And she stayed her ruling until May of this year, right? So that's something else that I'm also watching, right? The Biden administration may have begun work on that biological opinion. Let's see what happens from this administration as it picks up the pen. It's going to be really interesting to see what happens from there. And then the other thing, this is probably a good reason why I shouldn't make predictions, but I think like 4 months ago I was speaking at a seminar and was talking about the Endangered Species Act and the God Squad, which is a committee that can basically lift Endangered Species Act protections from a species that's been listed as endangered, and to allow whatever project or development to move forward, even if it could cause jeopardy, even if it could cause extinction to that species. And I said, nobody needs to worry about the God Squad. The God Squad's dead. Nobody's heard from it in forever.
You should have known. You should have known.
And I shouldn't have said that, because it's just shocking to me when something that I pay attention to ends up landing in a headline somewhere. And I've already seen, is the God Squad back? Are we going to hear from the God Squad as we try to unleash American energy? And we'll just have to see what happens. But that would.
And for the benefit of our listeners, so the Trump administration has reinstituted the God Squad, right? So they're kind of reconvening.
They resurrected it. I like to use resurrected
as a better term. But they've gotten the band back together, and they haven't taken any actions yet. But it remains to be seen sort of what their mandate will look like from the administration.
Right, and it's very clearly intentional, right? It's not like we're 2 years into this administration. They sort of dusted off the ESA, and they're like, "Oh, well, we can do this. That's cool." This was from the get-go. It's already been resurrected. We're going to see whether we hear from the God Squad. There's just so many things. Like I have on my list of things to talk about, the SEC climate disclosure rule, which was something that I was super interested in over the past couple of years. And the SEC's already notified the Sixth Circuit that it's pausing its defense of the rule. There's just so much to pay attention to. And yet we don't have tons of information yet. Like we've got the sort of the broad playbook. We've got really, or more, as you were pointing out, like principles, right? Go forth and review this. And we're not doing EJ or climate anymore, or at least in the same ways. How are the new appointees and the agencies going to carry out these pivots, and how are they going to affect specific rules? What new rules are we going to see? There's just a lot to talk about, which I think it's a great reason for somebody to subscribe to this podcast or check out our monthly webinars that we do for in-house counsel, to come to our seminar in May in Houston, because we are going to have so much to talk about.
There is so much to come. I think with this episode, I think you and I really wanted to kind of lay out what instructions have we seen? What are sort of the big hot button topics that we expect to track in the next few months as the administration really gets its bearings and starts taking certain actions maybe that we expect, but there could also be ones that we don't necessarily expect, because I think the playbook looks different for this administration than it did in 2017. In 2017, there was a lot of talk about the administration not necessarily being prepared to have won. I think Trump really took that personally, and he has gone about this differently. He was prepared. He is sending out orders. So I think we will continue to see progress on their part on energy and environmental issues, especially given the sort of priority that the president has placed on energy independence and promoting American energy. So I think the things that you and I have highlighted today are really ones to watch for our clients and colleagues, ones that we expect will be important to their business, important to the type of work that they do, and really are in a state of flux. It's much nicer, of course, to be able to deliver to someone, to anyone, very concrete advice about what they should expect and how they should be planning for this, how they should be planning for it in their budgets, how they should be planning for it in the types of investments they make or the types of energy projects maybe that they explore. This episode, I think, is not one for that, right? It's really one to say there's so much to come and there's a lot to pay attention to. Our, I think, purpose and really our entire practice group's goal is to kind of put this information down into digestible forms for everyone so that they can get what they need. And I think Daniel's right that our listeners, to the extent any of these issues piqued your interest or you thought to yourself like, wow, I really need to think about how that's going to impact my company's business, definitely subscribe to the podcast, listen to our webinars, come to our events, because we really will be spending, I think, at least the next 6 months sort of digesting, like, what do these things mean? The agencies have taken their instructions, they've started acting, what's going to happen next, and how does it impact our business? I think that's sort of our number one priority these days. And it's going to be fun for us. It's been fun for us already. It's been anxiety inducing, I think, for everyone because it's a little bit unpredictable. But I think it's fun for us to try to keep track of these things and advise and try to turn these issues into practical advice.
Yeah, I think that's all well said. I would just say stay frosty. It's moving fast.
Stay alert.
Stay alert. Sleep with one eye open. Oh, that sounds. That
one's too ominous,
that's right.
I think.
Well, I just listen to Metallica so regularly it just popped out. But definitely stay frosty. We will be getting back to a more regular podcast schedule. We are going to, if we don't hear anything from the administration soon, we're just going to come up with something to talk about. And we'll get into state environmental issues. Who knows? But it is great to have you back, Taylor.
Thank you.
Congratulations. And thank you all who've tuned in. We will be talking to you soon.